Hello, and welcome to the Freddie Mac Connect Perspectives on Policy and the Servicing Landscape session. Audience members are in listen-only mode. This session is being recorded and will be available following the conference. If you have any questions, please use the Q&A box at the bottom of your screen. If you have any technical issues, please use the Q&A box as well, and someone will assist you. Lastly, you will find icons at the bottom of the screen where you will find links to the speaker bios and the presentation deck. With that, I will turn it over to Ben Gotham, Vice President, Mortgage Servicing Policy at Freddie Mac. Ben, the floor is yours.
All right. Thank you, Amani, and thank you, everybody, for joining us today. The topic that we're going to be discussing is perspectives on policy in the servicing landscape, where we'll be talking about a number of topics regarding Freddie Mac's single-family servicing policy. Your speakers today will be myself, Ben Gottheim. I'm the Vice President of Mortgage Servicing Policy here at Freddie Mac. And with me, as always, is Ryan McGinnis, the Director in the same department here, Mortgage Servicing Policy here at Freddie Mac. So let's get right into our agenda. So we have 5 topics on our agenda, as you can see on your screen. We'll start off with recent policy updates. We'll talk about the expanded payment deferral. We'll talk about the COVID-19 policy updates, notably the retirement of the COVID-19 policies. And then I'll pass it over to Ryan to go through our disaster policy refresher and talk about some ongoing and future policy development. So let's get started. So first up, as we just said, we'll be talking about recent policy updates. On your screen, you'll see a couple screenshots of our most recent servicing bulletins. On the left is your bulletin from August 9th. On the right is our bulletin from October 11th. We wanted to make sure that we highlight both of these, October 11th being the most recent bulletin, but August 9th being probably the most substantial one we've done in a little while as it relates to our COVID-19 policy retirements. So again, August 9th, we had a bulletin. The top topic was around retirement of our COVID-19 related servicing policies. So this follows the expiration of the CARES Act that took place back in April. We also announced increases to a number of our expense reimbursement allowable limits, both in the legal space as well as property preservation and property inspections, as well as a number of other topics. On October 11th, we had another bulletin. In this bulletin, we announced our new functionality for charge-offs in our Resolve loss mitigation underwriting system. And as well, we also announced some updates regarding attorney networks. So given everything that has taken place in the last couple of years with the pandemic and people working from home or hybrid working, a lot of consolidation in this industry, between us and Fannie Mae, we felt it was time to ease some of those requirements regarding the attorney networks that you choose, notably around how many attorneys need to be in each individual state and whether they need to have a brick and mortar office. So hopefully this will help servicers as you start to pick up some of your foreclosure activity following the moratoriums and COVID-19 policies in selecting your attorneys. So let's move on and go into the next topic, which is our payment deferral expansion. So this was a big announcement for us. We did it earlier this year. And this is where we expanded the version of the payment deferral that was in the seller servicer guide that we happened to put in place right before COVID and was very lightly used. So if you recall, and I'll take you a look back a little bit, back in early 2020, we updated our guide to announce a new product at the time called the payment deferral. It was a solution for borrowers who had resolved hardships, maybe missed 1 or 2 payments. They were rolling delinquencies, and they otherwise couldn't afford to reinstate or do a repayment plan. Obviously, we put that policy out there, and then COVID-19 pandemic started. The national emergency was declared in March of 2020, and you basically never used the program because we introduced the COVID-19 payment deferral, which was a more expansive version of the payment deferral to account for up to 18 months of COVID-19 forbearance. We then expanded that program into our disaster payment deferral, which goes up to 12 months, again, following along with the disaster forbearance. So using lessons learned from the COVID-19 pandemic, and looking at a lot of our data between the GSEs, we knew we had to address the payment deferral before we were able to retire our COVID-19 policies. Knowing the success of the programs that we already had out there before, combined with the knowing that we can expand it beyond a 1 or 2 month rolling delinquency product, we created what we call the expanded payment deferral. And what the expanded payment deferral is, as you can see on your screen, is a solution for borrowers who have a resolved hardship, who have less than 6 months delinquency, and otherwise can't afford to reinstate or do a repayment plan, which are higher in the waterfall. So for these borrowers going forward, they'll be eligible for the new expanded payment deferral, and I'll go through some of those requirements right now. First, the delinquency has to be between 2 and 6 months. And I should point out that there actually is a cumulative delinquency of up to 12 months, which includes the fact that borrowers can do more than one payment deferral over the life of the loan. But for each individual payment deferral the borrower does, it would be for a borrower between 2 and 6 months. We did exclude 1 month or 30-day delinquent borrowers from this program. It doesn't mean that they're not always eligible. It can be done via an exception, but the general rule is that it would be 2 to 6 months. And the reason for that, I think most of you understand, is that the vast majority of borrowers who become 30 days delinquent ultimately reinstate their mortgage. And we don't want there to be any confusion about a borrower who may miss a payment and reinstate the next month. The payment deferral is not the right solution for them. So what else is part of this payment deferral program that's changed? A couple things. First, servicer advances. Servicer advances are able to be included in the deferred amount. That is different than the old program. It does match what we did for COVID and for disasters. Will no longer require the rolling delinquency. Again, 2 to 6 months delinquent is the parameters. There are some proactive solicitation requirements that we have layered in there, which didn't exist previously when it was only for those early stage delinquent borrowers. And lastly, borrowers may not be offered the payment deferral if they're within 36 months of maturity or their expected payoff date, should they have an earlier payoff date because of principal curtailments or whatever the case may be. And the reason there again is probably a little straightforward, but it's to make sure that a borrower is not going to be left with an unaffordable payment at the end of all of this, right? So borrowers can save up to make sure they pay off that deferred amount at the end of the loan through the life of the loan. But if it's that close, our concern would be that borrowers would not be able to afford the deferred amount that close after their hardship. So that is the expanded payment deferral. Next, I'll talk about COVID-19 policy retirement. So on the front end of our business, we retired our COVID selling policies a number of months ago. However, for servicing policies, we had to wait out the expiration of the CARES Act, which covered a lot of the activities that you as servicers must do during the COVID-19 pandemic and the national emergency. We had contemplated ending these policies a little bit earlier, but ultimately, with the law still in place, we weren't able to do so. So we did announce back in August that our COVID-19 policies will retire, and to make sure that you had a runway to implement this. They'll retire for any new hardship on or after November 1st of this year. Now, when I say on or after November 1st this year, what that means is one, no new COVID hardships on or after that day. If a borrower was already in a COVID forbearance prior to November 1st, they would stay in that COVID forbearance. But if the borrower's hardship begins on or after November 1st, they would follow our normal forbearance rules that are in the guide and not the COVID-19 forbearance rules. It also means that while we will retain reason for default code 032 for the National Emergency Declaration, in the event we have to use that code again in the future, we are instructing servicers to discontinue reporting that as of any new hardships on or after November 1st. Again, for any hardships that began prior to November 1st, you would continue to report the COVID-19 or 032 reason for default code, even after November 1st until the end of that individual borrower's hardship. Now, while those are retiring effective November 1st, obviously there are going to be borrowers who are going to continue to be on COVID-19 forbearances into the future. And for those borrowers, we want to make sure that the COVID-19 payment deferral and the flex modification rules around COVID will continue to be in play for those borrowers, as they do differ from what is in our guide, and they are a little bit more expansive. So for those borrowers who continue to be having COVID hardships into the next year, or at least after November of this year, right, the ones that are grandfathered in, they will continue to be eligible for COVID-19 payment deferral and for the flexibilities of the COVID-19 flex mod, as long as that loss mitigation solution is completed on or before November 1st of 2024. So with that, we've gone over, again, the expanded payment deferral, our retirement of our COVID-19 policies, and I'm going to turn this over to Ryan McGinnis to talk about our disaster policy and to do a refresher on that.
Thank you, Ben. An excellent job running through some of the things that we've accomplished recently in servicing policy with Freddie Mac. So again, I'm Ryan McGinnis, Director Servicing Policy for Freddie Mac, and I'm going to give a refresher today on our disaster policies. So as you all know, we have implemented kind of an off-the-shelf disaster playbook and corresponding policies for when disasters occur, so that we can assist borrowers who are in need after being impacted by a disaster event. So we wanted to go through this again. Now we're getting to the tail end of hurricane season, so you may have had to respond to some hurricanes. There, hopefully there will be no more hurricanes, but some of the impacts might continue. And then also there has been quite an increase in disaster-related events impacting borrowers over the last several years. So we like to run through this with you from time to time, just to do a little bit of a refresher. So with that, let's jump into it. So for Freddie Mac, the disaster policies are going to apply for when a disaster occurs. And so a borrower suffers a financial hardship based on that disaster. And how do we define exactly, when a borrower is impacted by what we call an eligible disaster? Well, there's several reasons for that. One, if the property securing the mortgage has experienced an insured loss. So this is a relatively newer concept for Freddie Mac's disaster policies that now kick in anytime an individual borrower might have a loss that is an insured loss, like let's say a tree falls on the house or something like that. That is a very personal disaster event, but it nevertheless is a disaster for that particular person. So we, in the last couple of years, expanded our disaster policy to cover those instances, because although it isn't a hurricane affecting an entire region, it is nevertheless just as significant in many cases to that particular person, and so these policies would kick in for that. Longer standing policy would be that the property securing the mortgage is in a FEMA declared disaster area where individual assistance has been made available. So this would cover, anything like a hurricane or wildfires where individual assistance is made available by the federal government, and where the mortgage premises or the home is located within that area. And lastly, similar, where there's a FEMA declared disaster with individual assistance, it can also apply if the borrower's place of employment is located in that designated area. So anytime any of these three scenarios occur, that kicks in our disaster policies that servicers follow to help borrowers and to help the servicers in managing the impact of those disaster events on the borrower. And a note here at the bottom of the screen that I did want to point out as well. There will be, there have been and probably will continue to be some instances where a borrower gets impacted by an eligible disaster while also actively impacted by a COVID-19 related hardship. In those cases, you're generally going to just continue to report the borrower as having that COVID-19 hardship. Now, the reason for that is that in some cases, the COVID-19 related relief options and workout options are a little bit more expansive than what we have in the disaster space. And that's because the pandemic lasted for a significant amount of time, more so than most disaster events will continue to impact a borrower. So for example, a payment deferral under disaster would only go up to 12 months of missed payments, but under COVID-19, it would go up to potentially 18 months. So we prefer to allow that flexibility for a borrower as long as the hardship continues to be ongoing as an active COVID-19 hardship. So with that, now you know, or you probably already knew, but now you have a refresher on when the disaster policies kick in and to whom they're made available. Now we're going to run through a process flow for the servicer's responsibilities when a disaster strikes. So we do have an entire guide chapter, 8404, devoted to disaster policy. In addition to that, throughout the guide, as relates to specific workout and relief options, we have disaster-related guidance. Like, for example, there's a section related to disaster payment deferral in the payment deferral area of the guide. There were special requirements for the FlexMod, and those will be in the FlexMod chapter of the guide related specifically to disaster. But when a disaster occurs, the servicer is going to want to make contact with the borrower, and communication is key. So communication both on the borrower side and the servicer side is very important, not just at the beginning of a disaster event, but throughout. So a servicer is going to determine that there's eligibility for the disaster policy. That's going to be different depending on the scenario. If it's a more regional event where individual assistance has been made available, then they're going to know the area that's impacted and might have to account for what could be possible damages in that area. If it's an individual situation with the borrower, it's probably in most cases going to be where borrower has to contact the servicer, because if the loan's current and a tree falls on the house, the servicer might not know right away, right? So there is some variability there. Once eligibility has been determined, property protection activities go into play. Servicer, of course, is responsible for ensuring the protection of Freddie Mac mortgage premises. It's both to help the borrower, but also to protect the collateral for Freddie Mac mortgages. So again, outreach is going to be important. Property protection can be accomplished through quality right party contact with the borrower and discussion with the borrower to find out the extent of damages, but also it could be with property inspections to the extent that those become necessary, the loan's delinquent, abandoned, things like that. So once that has been accomplished, there's going to be a series of other things that the servicer is going to need to do. There's certain disaster reporting requirements where Freddie Mac needs to get the reporting so that we know that there is a disaster hardship, that the property may have been impacted by the disaster event. There's going to be, going to the left side of the screen here, disbursement of insurance proceeds is going to be the responsibility of the servicer. So right up front, if there are losses for contents or living expenses, the servicer is going to immediately cut the check to the borrower to be able to cover those things. If there are damages to the property, then the servicer is also going to work with the borrower to manage the disbursements that might take place in order to be able to complete those repairs and work on a repair plan with the borrower and oversee that repair plan to make sure that those repairs are able to be completed. There's also delinquency management activities that the servicer is going to need to go into with the borrower. The borrower is impacted from a financial perspective and they're unable to pay the mortgage, then they're going to want to work with the borrower on that. The first option there, and the most important at the outset of a disaster, is forbearance, where the borrower can miss payments for a period of time without having to worry about things like foreclosure or late fees. And so there's two types of forbearance under disaster policy. The ideal situation is you're able to establish contact with the borrower and agree upon entering into a forbearance plan. If there's certain situations where you cannot QRPC, think back to some of the very severe hurricanes in Puerto Rico, where borrowers were hard to find in some cases. And so you have the authority, but never required, to enter into a forbearance plan without contact. Now, you want to be careful when doing that, because it really should only be if you absolutely have to. You don't want to put a borrower into a forbearance plan who's, let's say, current, and gets upset that maybe it might have impacted their credit score or something like that. So proceed with caution with that, but when it is necessary, it can be a helpful tool. And then as the borrower comes out of the forbearance, you're going to want to work on reinstatement options. We have a variety of reinstatement options that we're going to cover, but there is a difference between with quality right party contact and without. So if the servicer is able to accomplish quality right party contact, that makes for a much easier evaluation. That's always the ideal. You make sure you get the borrower into the right option. But we also do proactive solicitations to proactively make offers for things like payment deferrals and flex mods in the event that a forbearance ends without a resolution. And then borrowers on a trial period plan at the time of a disaster can convert to a forbearance plan without being penalized for failing the trial period plans, which would potentially impact eligibility if we didn't have that requirement in place. So we just talked about kind of the high level, how you transition from forbearance. Let's talk a little bit more detail about the specific options available to borrowers as they're coming off the forbearance. We have our full slate of reinstatement and relief options. So some of this is going to be, talk off with the borrower. That's why that quality right party contact is important. Can you afford to just reinstate? If so, great. Then a full or if you're a full reinstatement would be great. If not, a partial reinstatement combined with a repayment plan is also acceptable, or even no partial reinstatement and just a repayment plan if the borrower is able to afford repayment plan payments, which are going to be higher than the regular mortgage obligation for a period of time. They might need to continue on forbearance, you're right, because you're going to be contacting them before the forbearance plan ends, and maybe the hardship's ongoing, in which case you can extend the forbearance within our guidelines. And then we also have the payment deferral option. So payment deferral, as Ben went through, is now expanded to go up to 6 months for regular hardships. For the disaster payment deferral, it can be up to 12 missed payments to kind of match the full forbearance allotment under a disaster forbearance plan. So if the borrower is unable to afford the other options to reinstate, but they can't afford to make their regular payments, a disaster payment deferral is a great option for that borrower. If this hardship is turned into something longer term, a flex mod might be more appropriate. If they're unable to be able to meet the pre-existing payment obligation, they can go into a flex mod, which provides payment relief. And then unfortunately, if that's not going to work, we do have our liquidation options, the standard short sale and the standard deed in lieu of foreclosure. And unfortunately, even more so than that, not everybody can come to terms on a workout. And if necessary, foreclosure is the last option. But absolutely, we do everything we can to try to avoid that outcome. So let's talk some more about the post-forbearance transition. We're going to go through an example here of what this might look like. Okay, I'm just going to pull this whole thing out, go through all the steps, and then talk through it. All right, so in this case, we have a loan that was current as of September 2023, and a disaster occurred. The borrower's payments were $1,500 a month. They were impacted, so they could not afford to make those payments. So in October, they went into a forbearance plan, and they missed their first payment in October, another in November, another in December, another in January, another in February, another in March. So those six missed payments add up to a $9,000 obligation that is owed to reinstate the mortgage. So within 30 days of the end of that forbearance plan, you see the March with the green line going up to the bubble there. That's where the servicer must start to conduct outreach. Now, we do recommend periodic check-ins throughout the forbearance. It's always good to stay in touch with the borrower, not to the point of harassment, but certainly to keep them notified of their options. And but when you make that QRPC, in this example, you've done that, then you evaluate in the sequential order I talked about before, with the same kind of talk off I talked about before. And all of these options will reinstate the mortgage and get it back into the current status. All right, so now I'm going to transition to future policy development. Let's talk very briefly about what we're looking to do in the future, and then hopefully we'll have time for a couple of questions. One thing that we are continuously working on, and you might have seen our public plan. We have an equitable housing plan where we're going to continue in the servicing side, mostly to work in support of the various tactics in that plan. But some of the things that we're focused on there are borrower outreach, education, and counseling. We also are doing work to support some of the mortgage origination type of tactics that are involved, where we might provide some special servicing functions that can be in place to help manage what may be some higher risk products for us. FlexMod, as I'm sure everybody's aware, the interest rate environment has been a little bit different recently, where we went from very low rates to very high rates very quickly. So we're always evaluating the effectiveness of the FlexMod. It's important to consider a variety of dynamic economic environments, and we're doing that. So we're looking at how does FlexMod work now versus maybe how it worked in 2019 versus how it might work in an even more stressed environment, and what if any updates could we make to improve. For data and technology, this is something Freddie Mac's been very focused on in the past several years. We're trying to be innovative. We're trying to automate as much as possible. We're trying to be able to effectively utilize any and all meaningful data elements that servicers report to us. And so, we're doing that by Resolve, right? So Resolve is helping us to be able to have better data and be able to better evaluate the options that we have in place to hopefully be able to make smart decisions in the future. We're also trying to help in other areas of data collection and as well as automate certain functions that are not automated today. Like as an example, we are doing work to evaluate whether we can automate the evaluation of assumptions when borrowers request assumptions through using our LPA system. And so that's something that's going to be ongoing and that we'll continue to work through. So with that, I think we're at the question stage, and hopefully we have time for a few questions.
All right. Well, thank you, Ryan. Yep. So I think we do have a minute or two for a couple questions. Amani, if you're still there, I don't know if we have any questions in the chat box, but if we do you mind reading us those questions?
Absolutely. If you have any questions, please be sure to add them to the Q&A box and we will read them aloud. The first question is for Ben. What do we do if a borrower is on a COVID-19 forbearance before November 1st, 2023, and the initial forbearance plan ends after November 1st, but the borrower still has an active hardship?
Okay. All right. Well, I attempted to touch on that earlier, but let me expand on that as well. So again, no new COVID forbearances on or after November 1st. If the borrower was previously on one already, they continue. Now, a forbearance plan can only go up to 6 months. We allow up to 12 months of forbearance on the COVID-19 forbearance plan. So just because their initial forbearance may be ending after November 1st does not mean they're not eligible for forbearance going forward. So as an example, a borrower goes on to the COVID-19 forbearance in October, and then 6 months later, they still need additional help. At that point, it's not going to be considered a COVID-19 forbearance. It'll be considered a regular forbearance under the rules of the Seller Servicer Guide, specifically Chapter 9203. There's not that many differences between the guide forbearances and COVID-19, but one of the major ones is that normally forbearance is only limited up to 12 months of delinquency. So in the event a borrower started their forbearance initially while they were already 1 or 2 or maybe even more months delinquent, they'd only be eligible for up to 12 months of delinquency. Now, at that point, again, you follow the guide rules, but you continue to report that to us under the 032 reason for default code. And by doing that, that allows that borrower to continue to be eligible for the COVID-19 payment deferral and the COVID-19 FlexMod that we discussed earlier. All right, unfortunately, that's all the time we have for questions. So I just wanted to thank everybody for joining us on behalf of Ryan and myself. We always enjoy these opportunities to engage with you all, and we look forward to talking with you about servicing policy in the future. With that, I'll turn it over to Amani for any additional housekeeping items. Thank you.
That's all the questions we have time for today. If we did not get to your question, we will reach out to you following the conference. Your opinion is very important to us. Please take a few moments to take our brief survey so that we can continue to bring your timely and relevant content. The presentation deck will be sent to you following this session. You can also log in anytime after the conference to play back this session or any other session you choose. Thank you and enjoy the rest of the conference.